Hello and welcome to the GDPR and authors, how the EU's new regulation affects the business of authorship. So here's our overview of what this class is going to cover. I'm going to go through a brief introduction of myself. We're going to talk about the GDPR overall. We're going to go over some important definitions for you to know, the 6 principles that guide the GDPR, some GDPR article highlights, your key takeaways from the GDPR, and your compliance to-do list, as well as some resources to help you complete that to-do list. So quick intro. Who is Audrey? Who am I to teach this class? Because no, I am not a lawyer, but I am the founder of the Right Services Social Media Management, LLC, and the founder of the Author Transformation Alliance. If you don't really know what those are yet, go ahead, head over to our free Facebook group, Sprints and Spirits. It's a great place to learn about these things. We do a lot of writerly stuff. We have live writing sprints on video conference. It's a great place to not feel so alone as an author. But anyway, so if you want to check out more about that, I have links in the resource section. But my job is to help other authors navigate business systems, marketing, and other information that's critical for us to know in the industry. So before I did all this, and actually a little bit during, I spent 14 years in the defense industry. And during this 14 years, I had several, run-ins actually yearly with information regulations and legislation. So in the U.S. defense system, we already have legislation in place to protect information from a government aspect, and we have a lot of regulations regarding this. So there would often be times we would have yearly updates and yearly classes and training on how these regulations and legislation apply to us in our job capacity, as well as less or sooner than yearly updates. Whenever things changed or whenever there was some kind of incident, they would make us go through all of this training again and really, grill us on how these regulations and legislation apply to us. So in some of my positions in different units, my job was to interpret regulations in order to ensure that our standard operating procedures met those regulations or exceeded them. So this meant I spent a lot of time reading Army regulation and making sure that I was creating a standard operating procedure that met or exceeded that regulation. So I have a lot of experience with regulations and legislation and making sure that information is secure and that we're complying and doing the right thing. So that is where I'm coming from. Another part of my job for 14 years was researching something, and I would be given a topic and expected to really immerse myself in that topic and become the subject matter expert for my unit. So this meant I would research something and then synthesize that research so that I could provide critical information to key leaders, commanding officers, and make sure that they could confidently make informed decisions without having to immerse themselves in that subject. There are so many things we have to do, and there's so many things that a commanding officer or a key leader has to do, and they don't have time to learn everything about everything. That's why we delegate. That's why we give certain people certain research areas and then bring them all together, as long as we're confident in that person's abilities and their due diligence and their ethics, then we can make confident, informed decisions. So that has been my job for a very long time. And it's something I really enjoy doing. So I brought that skill and that experience to the writing community and from a business perspective, where I want to bring business fundamentals to authors. So this is one of those critical key pieces of authorship business that I knew that I had to create a class for. So I dove in, I read the articles of the GDPR, I took a very, very fast 4-week class. I did it in about a week and a half. I took a 4-week class on the GDPR, and I have dived into every article I could possibly find on the GDPR, and especially I'm in some social media manager communities where we've been talking about this, as well as making sure that I am up to date with one of the leading lawyers in the industry. I have spent a lot of time watching and reading from Suzanne Dibble, who I'm going to direct you to as well. So this is the merger between the legal and the technical. I wanted not just to give you a legal rundown, because there's a lot of lawyers already doing that. I wanted to tell you, as an author, what you need to be doing and the technical aspects that you have to be worried about, okay? So not just the legal, but we're gonna give you the how-to. So anyway, let's go ahead and get into it. The GDPR from the EU, what is it? It is the General Data Protection Regulation. It was actually passed back in 26 May 2016, but the intent was to be fully implemented by 26 May 2018, which means the last day to achieve your full compliance is 25 May. That's probably the date you're seeing a lot all over the internet. But it was designed to be a proactive means of protecting the privacy rights of individuals that are natural persons, not companies. But it is based, the whole regulation is based on the belief that privacy is a right. It's not something, it's not a privilege, it's a right. So let's go over those definitions real quick so we can move forward. And again, I don't want to take up a lot of your time. My whole point is to boil this down into what you need to know rather than drown you in all the nonsense. So you have time to get back to your writing or your editing or working with your cover designer. So anyway, natural versus legal persons. What does this mean? A natural person is like me talking to you. It's you. A legal person is an entity like a business. So you as an author, your business, your authorship business, or your publishing company, if you have to have a publishing company even to self-publish, then, or an LLC to publish, then you are, that is a legal person. That is a legal entity. And so that is not what the GDPR addresses. It addresses individuals. A data subject is, for example, someone who would sign up for your email list. The data controller, that is you. You are the person in charge of the email subscriber list and how many emails are sent out and what data you're collecting from people. The data processor is the entity who is processing the data or sending the emails or collecting the information. So for a quick example, if you use MailChimp, then you, the data controller, would use the data processor MailChimp to collect the subscriber information, the subscriber being your data subject. So hopefully that makes it easy. The data subject is typically the people who are our readers or who we would like to be our readers. So anyway, those are quick definitions. If you have any questions on that, let me know. Hopefully it's pretty clear though. So here are the 6 guiding principles of the GDPR. The first is lawfulness, fairness, and transparency. This means that data collection processes should be conducted in accordance with applicable laws. Collectors have to use clear and plain language, and collectors must be transparent about collection and processing activities. So they want you to be acting accordance with the laws. They want you to be fair to data subjects, and they want you to be transparent with data subjects. Purpose limitation. They only want you to collect data for the purposes you clearly stated to the subject. So if you say, sign up for my newsletter to get updates, then that is clearly stated. But if you then sell that information or sell that list to someone else, then that is not what you clearly stated. If you say, sign up for a free excerpt and that's it, then you add them to your regular newsletter list, then where they're going to get regular emails from you, then that's not clearly stated. So we have to be very clear and transparent about what we're using their information for. So the third principle is data minimization. And this is all about limiting what data we collect and making sure that's only what we're explicitly stating and what's reasonably necessary to the purpose of collection. So what that means is if we're just trying to build our email list, which most authors are, selling their books through a third party like Amazon or iTunes or what have you. But, if you are collecting payments then normally you're doing that through a data processor like PayPal. But when we're just doing an email list and that's all you're really doing on your own, then you have to limit that data collection. So do you really need someone's birthday? Do you need the state where they live? Do you need their address? Do you need their phone number? Are you really going to call them? Do you have to call them for them to be on your email list? What data do you really need? For example, on my list, I only ask for a first name and an email address. I really limit it to that because I don't need someone's last name. I only use their first name to personalize emails and show that I care how they feel when they open my emails. So that is what that means. Now, the fourth principle is accuracy. And this is the idea that data has to be kept accurate and updated. And any outdated or inaccurate data must be deleted. And we'll get more into that in your to-do list. So storage limitation, this is the concept that you should not be keeping data longer than is necessary for the purposes stated upon subject authorization. So if you had an email list that you have an email list and then you're deciding that you're not going to write books, you're not going to do the marketing anymore, you're just done with it, you're just whatever you're going to do, that's not part of your plan anymore. Then if you're not going to use it for the purposes stated when they consented to being on your list, then you need to delete that information. You should not be holding that data if you're no longer going to use it for the purposes you originally stated. Now, the final principle is integrity and confidentiality. And this refers to the security of someone's data. That data should be protected against unauthorized or unlawful processing, such as the case in renting or selling someone's information, or the Cambridge Analytica scandal, or any other scandal that we have seen. Any destruction or damage, that is something that we won't deal with. Typically as authors, implementing service, we should always implement services that use encryption and authentication, and most of us do. We're not really in a position to use services that don't use encryption and authentication. So I wouldn't really worry about that. But anyway, the whole idea is that think about this process and being as, having as much integrity as possible, and hold the confidentiality of subscribers' data, as an utmost principle, okay? So the one big takeaway is that you have to know that you are responsible for compliance with the GDPR. All right, next, we're going to go over subjects' rights according to the GDPR. So one of the first things that I want to get out of the way is that in line with the GDPR's guidance, minors are any data subject who is under 16 years old. So anyone who's younger than that, they are a minor and they cannot consent without their guardian's consent, okay? Now that that's out of the way, let's get to onto everybody else normal. But hopefully, you're not collecting minors' data. If your target reader audience is, consists of minors, then you should be hopefully marketing to their parents or their educators instead of, directly to minors. That is a very, very touchy area. So anyway, rights of access to data by subjects. So this rights of access has to do with they can go and see what information you have on them and how you've been using it, okay? This is thankfully a lot of these data processors, like, if you have ever seen anything from Infusionsoft, they provide a link where you click on the link if you want to unsubscribe, and you can also see what data they have on you, what lists you're signed up for with that controller, i.e. that marketer or person who has asked for your information. And but you can also click on subscribe from certain lists or from all the lists, and you can see how your data has been processed. So this is really, really helpful. So most providers, most data processors provide this information. Right to rectify. This right has to do with subjects being able to update any information that is incorrect. So if their name is incorrect, they should be able to go in and update that, either by notifying you, or if you have a processor like Infusionsoft that allows them to go in and see that information and update it. But either way, that's a right outlined by the GDPR, is that subjects can update their information. And subjects also have the right to object. So they have the right to object to processing or storage of their information, especially due to profiling activities. Typically, we don't do that. Profiling activities is like profiling buying behaviors or online behaviors, browsing behaviors, things like that. We typically don't deal with that. Okay. And any objection, though, whether that's just the processing, as in sending out emails, or the storage of anyone's information, means that you can no longer collect or process their information. And if you're using a Facebook pixel, you have to state that very clear on your website, but we're going to go over that in your to-do list. But anyway, you shouldn't have to worry too much about this. This is a very easy unsubscribe, and you can just easily comply with anyone's right to object. But you also have to clearly and plainly declare, demonstrate your compliance with this by clearly and plainly declaring that they have the right to object, that they have the right, to say they don't want their information processed or stored. Okay, so just state that, and we'll go over where to put that later. Now, here are some important articles that I pulled from the GDPR that I feel were especially actually applicable to authors and what we do at a level where we're just marketing through using email marketing and selling through a third party like Amazon. So automated decision making. So automation, this is exactly what it sounds like, and you have to understand before we get further into this that there are in accordance with the GDPR, there are 3 grounds for processing of data. There is contractual, where you have to process data in order to fulfill a contract. There's consensual, where someone says, yes, I would love to sign up for your newsletter, and then you process that information by collecting the information and sending them email. That processing is sending an email is as small as that. So, and then there's legitimate interest. So this means that you can stand on the ground of having a legitimate interest in sending this data, and it's not going to harm their rights or their legal status. So this is like when you say, hey, sign up for a free excerpt. I'll send you a free excerpt straight to your them address, and then you send them a series of emails that has to do with sharing what that book is about, and giving them maybe more excerpts, but that falls under legitimate interest. One thing we have to do in order to add them also to our newsletter list where they receive our regular newsletter, is we do have to get consent for that. We can't count that as legitimate interest since it's not directly tied to the purpose for what they signed up for, whereas a series around the book that excerpt came from would count as legitimate interest. And if I haven't made that clear enough, please comment, let me know, ask questions. I'll be happy to dive in any further on that if it's needed. So this automated decision making also refers to profiling and other types of activities that, again, like I said before, have the potential to affect the legal status of data subjects. And this stuff really refers to stuff that's above our heads. So as long as you're not, collecting sensitive data like, their birthday, their answers to what would be typically challenge questions, their address, their phone number, their payment information, their bank accounts. If you're not collecting that stuff, we're typically out of the second bullet. But that is where the GDPR creators were really concerned with profiling activities and automated decision making. They didn't want your information or EU citizens' information to be automatically added to new processing, when it could affect, when it presents a high risk. So the next article is Article 30, records maintenance. And this refers to maintenance and security. It states that the controllers must maintain records of all processing activity. Thankfully, this is really easy to do with like MailChimp or something. We can see the emails we've sent out. We can see the automations that someone has been through, or the series that someone has been through, or the different lists that they're on. So it's really easy to maintain records. But Any controller can be exempt from the obligation to maintain records of processing activities if they have less than 250 employees. Um, Except in the cases where the data processed affects their rights, legal status, or freedom, or includes sensitive information such as biometrics, profiling, ethnicity, etc. Any of that kind of stuff is like highly sensitive information, or the rights or legal status or freedom. That's typically like payments or, again, really sensitive data that we don't typically collect. So hopefully you're just collecting a name and an email address, because then you will be exempt from this 250 employees or less. But again, it's really easy to comply with this, even if you're exempt, because MailChimp and things like that can easily show records of what activities we've conducted with these data subjects information. So again, it's really easy just to comply with this in our case. So Articles 33 and 34 deal with data breaches. And in the case of a data breach, a processor, who are the people who typically hold the information that we collect as data controllers, our processors like MailChimp or ConvertKit, they have to notify us immediately in case of data breaches. And we should always notify subjects, our data subjects, like the people on our subscriber list. We should always notify them. It's the right thing to do, but it says that we don't have to notify them unless there's been a breach that presents a high risk to their rights and freedoms. So I do collect payments through PayPal. So if there's a data breach with PayPal, I have to notify those people who I have information on in PayPal and let them know that PayPal had data breach. Fortunately, I don't keep any subscriber data on my own laptop. That is the kind of case where if you were keeping subscriber data on your personal system, your PC or your computer, you would have to, put in security measures and barriers, like always locking it, never leaving your computer alone. Maybe you go to Panera and you feel comfortable leaving your computer on the table when you go to the bathroom. That's not okay if you store, it shouldn't be okay anyway, but it's definitely not okay if you store any subscriber data on your computer. So if you download those CSV files and use them for anything, go ahead and delete them. Delete them after you're done using them, so they're not even on your system and you don't have to worry about someone having a breach that way. Okay. So Article 37 has to do with the DPO. What is a DPO? It is a data processing officer. And this article states that you have to have a data processing officer if any processing is conducted by a public authority or body, which ours is not. Regular and systematic monitoring of data subjects on a large scale. This is vague, but typically we are not. This was really intended for the big guys like Facebook and Google, especially Google. A lot of the cases against Google help drive this legislation or this regulation. So processing on a large scale of sensitive data, again, that is highly sensitive data. That's not names and email addresses. That's not sensitive data. So do you need a data protection officer? Again, I want to reemphasize that this regulation was not designed to regulate solopreneurs, authorpreneurs, small business owners. It was designed to hold large companies accountable and give them a code of ethics that they could not create on their own. Obviously, they were not, the EU members feel that these businesses were not capable of, handling data subjects' data and information in an ethical manner. So that's why this was created. Google, Facebook, the big ones. This is who they have seen as a problem, not small businesses, but they want all businesses to be compliant to the best of their ability. So although the regulation does apply to us on a large scale, there are some parts that just don't, like the data protection officer. And many parts are vague, such as processing on a large scale, which is mentioned. Those words are mentioned verbatim in that article for the data protection officer. But that doesn't mean anything. There is no definition there. There is no refinement of what is a large scale and which data. So is it 2,000 subscribers? Is it 10,000 subscribers? Is it not email subscribers at all? So they are not clear on that. And that's a point where we're just going to have to wait for case law to come out. So but if you are processing sensitive information or conducting any monitoring of subjects, then you need a DPO. But again, as authors, and which is why I created this class, we're not doing these kinds of things, especially if you're just running an email list and that's about all you do. You don't need a data processing officer. I mean, even if you're doing social media and stuff like that, you're not conducting monitoring of subjects. So if you have any questions on, well, I do this or I do that, go ahead and post them in the comments and let me know. So your data processor. So one of the things you have to do, and I'll highlight as one of the first things to do, is ask your data processor like MailChimp or ConvertKit or your website provider or your website host, your domain host. Ask them if they are GDPR compliant. Again, compliance is your responsibility, and you have to use services that are compliant. So if you're not using services that are compliant, the buck doesn't fall on them, it falls on you. Only use data processors who are compliant. MailChimp has demonstrated or has stated their compliance, so has ConvertKit and MailerLite. Of course, Facebook has, and so has Google. Their privacy policies are a lot longer to read, but they very, very much go into detail and have worked very hard to be GDPR compliant. So here are your key takeaways. All natural persons, which are people, not companies, have a right to privacy, information accuracy, objection, deletion, etc. Next, GDPR is a major step to protect individuals' rights in an increasingly data-driven technological age, and it's a good thing. Okay, so, and again, this regulation is designed to catch the big guy. It's not designed to catch unaware people in a bad spot and then slap them with a 20 million euro fine. I know everybody's focusing on those fines, but that's not what's going to happen, okay? So there is no massive compliance force to go out and have like an actual person or even an algorithm go and check every single website to make sure that their privacy policy is correct, or to make sure that they're doing the right thing. It's based on a reporting system. So if an EU citizen reports you as not being compliant, then you'll get a warning, and you'll have an opportunity to work with a representative from this compliance, or from that member state's supervising authority, to get compliant, to make yourself compliant. And it's only if you don't comply with the warnings and then comply with that supervising authority that you'll get fined, okay? So I wouldn't really worry. Everybody's like, oh, 20 million euros, it's so serious. But they're not just going to give you a 20 million euro fine. They're going to work with you and try to help you get compliant. Their goal is not to crush small businesses. And as an author, you are a small business owner, of course. So anyway, another key takeaway, it just requires a combination of common sense and due diligence to comply with this. Just update whatever you can, invest in updates if possible, or you can get in there and use your own fingers. I've included a resource that gives you an outline of what you need to include. And if you can't afford the $600 or $1,000 for what is in high demand right now, and any lawyer who specializes and actually knows their stuff about this regulation and how we need to be compliant. If you don't have that kind of money, then there are ways you can still use your due diligence to try your best to be compliant. And that's what it is. You just need to have that, that ethical fire to do whatever you can. Even if you can't invest, you can still go in there and type the addition to your privacy policy if you have to, because I know there are so many people out there who are like, well, I don't have $100, for the privacy policy generator, and terms feed is one of the best, but you do end up paying quite a bit for it if you want all the right stuff in there. It could be around $100, and it was a little over $100 for me, but it's different for each person's situation. But again, you have to have CalOPA, which is an upgrade. You have to have GDPR, which is an upgrade. You have to have all these different pieces, and it ends up being like $100. So try to save up for that so you can invest, so that you can be tippity top shape. But until you can, there are still bullets that you can add and say, I've done my due diligence. I'm really, giving it my best effort to tell you what I'm collecting, why I'm collecting it, what I'm going to use your data for, and that I will not, or if you do, hopefully you don't sell subscribers' data or rent it or give away. But if you do, you have to clearly state that. Clear and plain language is the big takeaway there. And again, I can't emphasize this enough. Make sure that any of your service providers, your data processors, are GDPR compliant. And that's not just MailChimp or whatever email, CRM you're using. You also have to make sure your website host is GDPR compliant. Otherwise, you got to change. You got to make sure, all your website plugins for like WordPress, make sure that they're GDPR compliant, okay? So make sure all that stuff is up to date, because there's certain plugins. If you're going to use, there's a plugin for WordPress that does your terms of service and your privacy policy, but you have to make sure that's not necessarily a magic bullet. Does it actually include the terminology required for the GDPR? And does it actually let you personalize it, or does it kind of just give you a standard thing that may or may not actually apply to your situation? So be very careful with these things and make sure they're actually in compliance with GDPR, not just like, maybe. So ensure that any service for your terms of service or privacy policy include that terminology again. And anytime you get your new terms of service or your privacy policy, comb through the wording yourself to make sure it actually applies to you. Okay, because if it says, we may or may not use your data for further marketing purposes, that's not clear and plain language, which the GDPR makes constant emphasis that we need to use clear and plain language. And if you're doing the may or may not, then it's not clear and plain. It's not clear what you're doing with the data. So let's just make sure that it's clear, okay? And until you have the money for a lawyer to do this, and let's cross our fingers that you're really going to get to that point soon with your book sale revenue. But until you do, we have to try our best and give our best effort to do this with a combination of generators and of our own understanding. So anyway, but just make sure you're going through the wording and making sure it actually applies to you. If you don't understand it, then I have no doubt that the people you're collecting data on don't understand it either. And that's where we have a problem. So anyway, remember the basis for processing, contractual, consensual, and legitimate interest. Contract is when, you have to process that data or use someone's email address to fulfill a contract. And typically authors aren't doing that. But consensual, that's when you're, using BookFunnel to give away a book or saying, hey, sign up for my free excerpts or whatever it is. That's consensual. And legitimate interest is when you maybe, they sign up for that free excerpt and then you send them a few emails about that book the excerpt came from. And of course, you just send them those emails and not your regular emails. But that's legitimate interest. And we can mark it on those grounds to an extent. Just don't toe the line, okay? Just try to be very clear and just very straightforward with people about what you're going to do. And if you want them to join your regular email list and they haven't agreed to it, then, make another case for it. You just be like you were talking to your friend, if you're writing an email and telling them why they should join your list, okay? So anyway, but just remember contractual, consensual, and legitimate interest. Okay, so remember that using any templates for the privacy policy or the terms of service or cookies policy can be iffy. Again, I can't emphasize it enough. Maybe this is enough. The GDPR requires us to be very specific about what we're doing with data, how we're processing it, et cetera, et cetera. And we have to use that clear and plain language to communicate these things, okay? If the templates say we may or may not use your data or sell your data or rent your data or may or may not anything, then that seems insufficient. It's not clear and plain, and that shows a lack of due diligence. So don't lack due diligence. You can do this, I promise. But without case law as precedents, we are left to do our best, okay? So do your absolute best, and if somebody says it's not right, then figure out, say, okay, what do I need to do to make it right? And when, again, if you do get a warning, if someone reports you, if some EU citizen reports you as having an insufficient privacy policy, then you're going to get a warning and they're going to tell you how you can be compliant. And you can communicate with a supervising authority. It's not like, they're just going to slap you with a fine. So you're going to have time. This is not some big blowout. I want you to be compliant in time, but do the best you can with what you have, okay, with the resources that you have. And again, I'm going to have a great resource section for you to focus on, building, making sure that you are compliant, okay? So here is your compliance to-do list. I hope you're ready to take notes, all right? Update the terms of service on your website. Again, you can use a generator, or you can just comb through it yourself and see if it's still applicable and then give an updated date, last updated whatever day you're watching this. Update your privacy policy. Again, provide a last updated, and I'm going to give you again a resource in the resources section that gives you bullets of what needs to be included in your privacy policy in order to be compliant with GDPR. And again, if you really, really, really don't have the money for a privacy policy generator, I know people personally who coming up with $109 would just be out of the question. If you really don't, then use that resource to put it in yourself, okay? Again, clear and plain language, be truthful, don't try to hide anything, just be very honest and upfront about what you're doing, with this information. But anyway, so you can look through that, but if you can scrape together $100, TermsFeed has a great generator that has all of this stuff required in the privacy policy and does a very good job of tailoring it to you. You also need to update your footer to declare your cookies policy. Like if you use Google Analytics or Facebook Pixel to retarget readers after they've been to your website, then you need to declare this on the footer. And this is something Facebook did, warn or tell us about. They said we needed to, state it on our website. So at least they've told us. But it's one of those things where you get an email saying we've updated our policy about pixels and we don't read it, okay? But thankfully I'm in a community of, several communities of social media managers, and this is something we've been talking about a lot and getting really in the weeds on. And basically you have to have this declared, not just in the footer on one page or your home page. It has to be declared on every single page of your website. Okay, not just one, but all pages of your website. So this is why I've actually changed the layout of my website. I used to have the ATA members area be just like kind of its own self-contained site, and I would remove the header and the footer so that it was, had its own environment and its own feel from the rest of the public-facing website. But since we have to, declare this cookies policy and the Facebook Pixel thing on every single page, I've just reverted to the standard layout so that it's easily right there in the footer and I don't have to create something new for every single page. I have a lot of pages, so this made it very, very easy. But anyway, so make sure that if you use Google Analytics or Facebook Pixel or anything else like that that tracks your traffic or anything like that, then you have to declare that, very, very clearly. Update all your data collection forms, like your landing pages and your pop-up forms, to provide a clear link to your privacy policy, okay? So that's your next thing in the checklist, all your data collection forms. And this means your standalone landing pages from MailChimp or your pop-ups that are on your website, anything that's embedded. We have to have, especially if you're using a freebie to get people onto your newsletter list, then make sure you have that checkbox in place that they can check that says, yes, I'd like to also receive your, or I consent to receive your regular emails as well. And that box cannot be pre-ticked. It has to be open and clear, and they have to click it, okay? Update all of those data collection forms, whether it's landing page or pop-ups, to only collect information required for processing. So think about this. Look at each piece and say, do I really need to know this information? With email address, yeah. We need to know that in order to send emails and send them freebies or free excerpts. But do we need their first name? Me, I do, because I like to personalize my, my emails, and I think it changes the experience. So I want that kind of personalized experience for my subscribers. Do I need a last name? No. Do you need a last name? That's up to you. Think about whether or not you really need it, and then start fixing those data collection forms. All forms should be explicit on the purpose that they're being, they're collecting data for, okay? So make very sure that they are explicit about what they're collecting. So if you need to say it, then you say either they're explicitly signing up for your regular newsletter, or they're signing up for an excerpt and receiving a series of emails with excerpts and background information on the book that the excerpt is from. So next, make sure you enable a double opt-in, okay? So a double opt-in typically sends an extra email after they initially sign up to confirm that they do want to actually receive the emails. And this double opt-in is really, again, it's all about the due diligence and making sure that you're doing the right thing and being very transparent about what you're collecting information for and what you're doing with it. So definitely enable those double opt-ins wherever possible. Okay, so next, again, make sure that there aren't any pre-ticked boxes on your data collection form. So when you're asking people to sign up for a free excerpt and you want them to sign up for your, regular newsletter or regular emails in the same form, and, put a checkbox there, but do not have it pre-ticked, okay? And hopefully most processors are going to be, updating that to where it's not even an option anymore. But just in case it is, make sure that it's not pre-ticked, okay? And then ensure your email software as a service is GDPR compliant. Like I said, MailChimp, ConvertKit, and MailerLite are already, but always just Google search, your email provider, email campaign manager, and then GDPR. So that will typically bring up an article or a blog post where that provider's representatives talk about their GDPR compliance efforts. But just make sure they are. So anyway, research if your website provider is GDPR compliant, whoever's hosting your website, whether it's WordPress, Wix, Bluehost, whatever it is. Again, Google search their name and GDPR. Then send an email to your list to declare your own efforts to be compliant with the GDPR. Direct them to your new privacy policy, and maybe even give them a summary of the changes or the summary of what you do again, and then directly offer them the opportunity to unsubscribe. Okay, so we want to make sure they're only on our list if they really want to be. We don't want to keep people trapped on our list, and that would suck anyway, because we don't want people to have or we don't want to have people on our list who aren't opening our email. So what's the point of having 3,000 email subscribers if only 200 of them are actually opening your emails? So definitely offer them the opportunity to unsubscribe and make sure that they actually want to be there. We don't want to send them emails if they don't want to read them, okay? So anyway, here are your resources. There is MailChimp's GDPR guide. We Will Thrive is a UK company which has provided a GDPR compliant privacy policy template, which is free. There's a video on GDPR, Busting the Myths by Suzanne Dibble, who I mentioned previously. I also linked for you Suzanne Dibble's website and her Facebook group that you can join and watch all of her videos if you have any extra questions. And if you want to get a little bit deeper, again, it's not geared towards authors. It's typically geared towards entrepreneurs and other like small businesses. But that's why I created this course, because I thought we need to have something for authors here too, to bring together the legal and the technical aspects. So there's a free in-depth course by FutureLearn. That is a 4-week course, but you can get it done sooner. And again, you have to understand before you take this course that it is geared towards large organizations. It is not geared for authors. It is not oriented for small businesses or entrepreneurs, okay? Termsfeed.com has a great generator for terms of service and privacy policies, and that does ensure compliance with CalAPA and GDPR. So those are the, resources we have for you. I really hope that you enjoyed this class. And if you have any questions, please feel free to send me those questions. You can comment. If you're in the ATA on this class page, I have the printable checklist, and we're going to have a Q&A session on May 22nd at 1 p.m. So be sure, and if you are not able to attend live, go to the event in our private Facebook group and you can post your questions and I'll be sure to answer them so that you'll still get to see the recording of those questions being answered. So anyway, I hope this has done a good job for you in bringing together the GDPR and what it means for authors and the business of authorship. It's been made out to be pretty scary, but I hope this has helped you see that even though it's pretty serious business, it doesn't have to be scary. And hopefully you see that the compliance to-do list isn't that terrible. So anyway, I'm going to go ahead and pop off here and I'll see you guys on the other side. Bye.